If you're a senior living in rented housing in the UK, what I'm about to tell you could completely change how you live for the rest of your life. Parliament has passed what many are calling the biggest shake-up to housing law in decades. And if you're over 60, this isn't just news, this is personal. For years, landlords held all the power. One notice, and you're out. No real reason needed, no real fight possible. That's gone now. Section 21, the so-called no-fault eviction, is being scrapped. But here's the question nobody's asking loud enough. What does that actually mean for you, the tenant who's spent decades building a home, not just renting a roof over your head? Because here's the twist. New rules also mean new grounds for landlords to remove tenants, new standards, new rights, new responsibilities. Some seniors are going to come out of this massively protected. Others could be caught completely off guard if they don't know what's changing and when. And it's not just about evictions. We're talking pets, rent increases, housing conditions, even how landlords have to treat you going forward. This law touches almost every corner of renting in England. So if you or someone you love is a senior renter, you cannot afford to scroll past this. I'm breaking down exactly what's changing when it kicks in and, most importantly, what you need to do right now to protect yourself. Stick around till the end, because one detail near the end could be the one that saves you the most money. Hit that like button before we dive in. It genuinely helps more seniors find this video. All right, let's get into it, because once you understand this, you'll see why so many people are talking about it right now. So let's rewind for a second. Parliament passed the Renters' Rights Act back in October 2025, and it received royal assent then. But here's the part most people miss. Laws like this don't flip on overnight. They roll out in phases, and the first major phase is landing on the 1st of May 2026. That's not some far-off future date. That's happening right now in real time. And if you're a senior tenant, this is the moment you need to be paying attention. For years, if you were renting in England, there was this thing hanging over your head called a Section 21 notice. Landlords could use it to remove a tenant with basically zero explanation. No wrongdoing needed, no real justification, just 2 months, and you're expected to pack up a life you may have built over 10, 15, 20 years and walk away. For seniors especially, that kind of uncertainty isn't just inconvenient, it's terrifying. Imagine being 70 years old, settled into a home filled with memories, medical routines, familiar neighbors, and one letter can undo all of it. That fear has been real for millions of renters for decades. But now that chapter is officially closing. So what actually changes in Phase 1? The no-fault eviction is being abolished. Assured short-hold tenancies, the standard rental agreement most landlords have used for years, are being phased out entirely. In their place comes a new system built around specific, defined grounds for eviction. That means landlords can no longer simply decide they want you gone. They now have to prove a real, lawful reason. That single shift rebalances a relationship that has, for a long time, tilted heavily in the landlord's favor. Now, I know what some of you might be thinking. Does this mean landlords can't remove tenants at all anymore? No, that's not quite right. And this is where it gets important. The new grounds for possession still exist. Landlords can still reclaim a property under specific circumstances, such as needing to sell or move in themselves. But the key difference is transparency. You now have the right to actually know why you're being asked to leave, and there's a structure around how and when that can happen. For seniors on fixed incomes in familiar communities near doctors and support networks, this predictability could be the difference between stability and upheaval. But Phase 1 is just the beginning. There's more coming down the pipeline, and this next part is honestly where things get even more interesting for older renters specifically. Future phases are expected to introduce a landlord database, essentially a registry that tracks landlord behavior and compliance. Alongside that, a new private rented sector ombudsman is being introduced, giving tenants somewhere real to turn when disputes happen, instead of just hoping a landlord does the right thing. And housing condition standards are being strengthened too, meaning the bar for what counts as a livable, safe home is being raised. Now, if you're in social housing rather than private rental, listen closely because this part matters just as much. There's growing pressure around something called the Decent Homes Standard, and recent reports have found that hundreds of thousands of social homes across the country are failing to meet it. We're talking about issues like damp, overcrowding, and poor energy efficiency, problems that disproportionately affect older residents who may already be dealing with health vulnerabilities. The government has been pushed to set clearer targets and timelines to fix this, and that pressure is only growing louder. And here's something else quietly shifting in the background, something that might sound small, but actually says a lot about the direction all of this is heading. The housing minister has written directly to social landlords, urging them to fairly consider tenant requests to keep pets. Now, that might not sound like headline news, but think about what it represents. For a lot of seniors, a pet isn't just an animal, it's companionship, it's routine, it's emotional support during years that can otherwise feel isolating. The fact that this is even being addressed at a policy level tells you the conversation around senior housing rights is expanding beyond just eviction protection. So where does that leave you right now, today? If you're a senior renting privately, your protections around eviction are strengthening dramatically starting this year. If you're in social housing, standards are being scrutinized like never before, and there's real pressure for measurable improvement. But, and this is a big but, none of these protections work in your favor if you don't understand them. Rights on paper don't help you if you don't know they exist. And there's one more piece to this puzzle that I haven't even touched yet. Something involving rent increases and how landlords are now required to justify them, plus a detail about transition timelines that could directly affect anyone currently in an existing tenancy agreement. That part alone could determine whether you're fully protected right now, or whether you're sitting in a legal grey zone without even realizing it. Let's talk about rent increases, because this is one of those areas where confusion causes real financial pain. Under the old system, many tenants simply accepted whatever rent hike letter landed in their mailbox, assuming there was nothing they could do about it. That's changing. Under the new framework, landlords are required to follow a clearer, more accountable process when raising rent, and tenants are being given stronger footing to challenge increases that seem excessive or unjustified. For someone living on a pension or fixed retirement income, this matters enormously. A sudden, unexplained rent jump isn't just an inconvenience. It can mean the difference between staying in your home or being priced out of the community you've lived in for years. Knowing that there's now a structure to question and push back against unfair increases gives you something you didn't have before: leverage. Now here's the part that trips a lot of people up: the transition timeline. Because this law isn't flipping a switch for every single tenancy in the country on the exact same day. If you're already in an existing tenancy agreement, there are specific rules about how and when the new protections apply to you. This is critical because it means two neighbors living in identical buildings could technically be covered under different timelines depending on when their tenancy started and how their landlord chooses to proceed. If you don't check where you personally stand in that timeline, you could assume you're protected under the new rules when you're actually still sitting under older terms for a little while longer. That's not something to guess about. That's something to actually verify, ideally with guidance from a tenants' rights organization or legal advisor who can look at your specific agreement. And this is exactly why so many housing advocates are urging seniors specifically to not just hear about this law, but to actually understand how it applies to their individual situation. Because broad headlines like "biggest housing law in decades" sound reassuring, but real protection comes down to the details. Your tenancy start date, your landlord's registration status, whether you're in private rental or social housing, and what phase of rollout currently applies to you. Let's also talk briefly about safety and living conditions, because that's another thread running through all of this. There's been a growing push around minimum housing standards, especially in social housing, following reports of serious issues like damp, mold, and poor insulation affecting a shocking number of homes. For older residents, these aren't just cosmetic annoyances, they're genuine health risks. Damp and cold homes are directly linked to respiratory issues and other health complications that hit seniors harder than younger tenants. The heightened scrutiny on these standards means there's now more pressure than ever on landlords and housing authorities to fix these problems, rather than letting them linger year after year. So here's what I want you to walk away with. This law isn't just political noise or a headline that fades in a week. It's a real, structural shift in how renting works in this country, and it's rolling out in stages that are happening right now in 2026. If you're a senior renter, private or social, your protections are expanding. Your rights to challenge unfair treatment are strengthening, and there's finally more accountability being built into a system that for a long time left older tenants especially vulnerable. But protection only works if you use it. That means checking your tenancy agreement, understanding which phase of the rollout applies to your situation, and not being afraid to ask questions or seek support if something about your housing situation feels unfair or unclear. There are tenant advocacy groups and housing charities specifically set up to help walk you through exactly where you stand, and reaching out to them costs nothing but a phone call or a quick search online. This is one of those moments where staying informed isn't optional. It's essential. Housing security affects everything else in life. Your health, your peace of mind, your sense of stability in your later years. And with a change this significant happening in real time, the people who come out ahead are going to be the ones who took the time to actually understand what's shifting beneath their feet, instead of finding out the hard way when it's already too late. So if this video helped make sense of a law that honestly sounds a lot more complicated than it needs to be, do me a favor and hit that like button right now. It genuinely helps this information reach more seniors who need to hear it, and it helps this channel keep breaking down policies like this in plain, simple language instead of confusing legal jargon. Share it with a parent, a grandparent, a neighbor, anyone you know who's renting and might not have heard about this yet. Because the truth is, laws like this only protect people who know they exist. And now, you do.